The New Jersey Open Public Meetings Law was enacted to ensure the right of the public to have advance notice of and to attend the meetings of public bodies at which any business affecting their interests is discussed or acted upon. In accordance with the provisions of the Act, the Hopewell Valley Regional Board of Education has caused notice of this meeting to be published by having the date, time, and place thereof communicated to the Hopewell Valley News and the Times on January 7, 2025. This meeting notice was also sent to Comcast Cable and Verizon Fios. The board reserves the right to enter into executive session during all meetings of the Board of Education. The meeting is being recorded for the purpose of board review, future reference, preparation of the minutes, and viewing on YouTube, Bulldog TV, and the school district website, www.hvrsd.org. Please join me in a flag salute. Okay. So just to kind of explain for new folks and folks who are watching on TV why the board secretary is handling the meeting at this point. As I mentioned, this is the board organizational meeting. It's the one time of the year where the board is coming together to be reformed, to elect a president and vice president, and begin their work. And by rule, the board secretary has all the power. So I could let this meeting go a long time and just kind of filibuster, but nobody would really want that. So my first order of business tonight is to record or report the election results. Just shout out again that that election did produce a successful referendum by the board, and we have been actively ongoing getting that started. We've met with many of our professionals and are preparing to sell bonds in a few weeks. We had our bond rating call today with Standard & Poor's, and hopefully we get the same or a better rating than we got when we did the resale. So that's all good, but for tonight's purposes, elected to the board from Hopewell Township to a 3-year term with 4,946 votes was Hope Cotter. Welcome aboard. And re-elected to the board with 4,694 votes, Amanda Stiliano. So welcome back. And also being re-elected to a 3-year term, Mark Peters with 776 votes. Okay. So the next.
That's all that matters.
The next bit is will join me back at the podium to take your oaths of office. Make it easy so we don't have to. Please don't state your name. So we can we'll repeat after me. We'll just run through each of the parts that you guys sign. Okay. I state your name. Yeah.
Okay. I, Amanda Stiliano,
do solemnly swear or affirm
do solemnly swear or affirm
that I will support the Constitution of the United States
that I will support the Constitution of the United States
and the Constitution of the State of New Jersey,
and the Constitution of the State of New Jersey,
and that I will bear true faith and allegiance
and that I will bear true faith and allegiance
to the same
to the same
and to the governments established
and to the governments established
in the United States and this state,
in the United States and this state,
under the authority of the people,
under the authority of the people,
so help me God.
so help me
I state your name.
God. I, Amanda Stiliano,
Do solemnly swear or affirm
do solemnly swear or affirm
that I possess the qualifications prescribed by law
that I possess the qualifications prescribed by law
for the office of member of the Hopewell Valley Regional Board of Education,
for the office of member of the Hopewell Valley Regional Board of Education,
am not disqualified as a voter
am not disqualified as a voter
pursuant to RS 19:4-1.
Pursuant to RS 19:4-1.
Am not disqualified due to conviction of a crime
And not disqualified due to conviction of a crime
or offense listed in NJSA 18A:12-1.
or offense listed in NJSA 18A:12-1.
And that I will faithfully,
And that I will faithfully,
impartially,
impartially,
and justly perform all the duties
and justly perform all the duties
of that office according to the best of my ability.
of that office according to the best of my ability.
So help me God.
So help me God.
Welcome back and welcome to. I'm going to give you your pen. I will take your John Hancock. Just take the top and you put the bottom. Just the top. Official. You guys want to get a? Did you get a picture? You want a full picture of them all together, holding their certificates up? You good? You guys all good?
Yeah, we need to get that on the website.
Yeah.
Like a problem.
Okay. Now that we have sworn-in board members, we can take the roll. So, Ms. Cotter, Dr. Genovese, Dr. Lilliston,
Here.
Mr. Peters.
Yep.
Mr. Slotman.
Here.
Dr. Stiliano.
Here.
Ms. Williams Galliano.
Here.
We have a quorum. All right. The next order of business is, as board secretary, my final act would be to conduct the election of president of the Board of Education. I will call for nominations for the office of board president. No second is required. At the close of nominations, I will take a roll call vote of each member asking you to state your selection for board president. If there is only one nomination, I will conduct a voice vote of yeas, nays, or abstentions. Once a president has been selected, I will step down as temporary chair of the meeting and pass the gavel to the newly elected president, who will then conduct the election for the office of vice president in the same manner. Okay, nominations are open for president of the Board of Education.
I will nominate Anita Williams Galliano.
Okay, are there any other nominations? Seeing none. All those in favor of Anita Williams Galliano serving as president for the 2006 year, say aye.
Aye.
Any opposed? Okay, Anita, welcome back. 126. What's that? Oh, 26. Same thing.
Yeah, I don't want to
Okay.
go. Stay where we are. Congratulations.
Now you
I
can
know
go
where it is.
through the script.
Yeah. Seat shuffle. Wear it well. Thank you all for voting another year of leadership for this amazing team So I will call for nominations for the office of Board Vice President. No second is necessary. At the close of nominations, I will take a roll call vote for each member, asking you to state your selection for Board Vice President. If there is only one nomination, I will conduct a voice vote of yeas and nays or abstentions. This will conclude the election of officers for the 2026 calendar year. Accepting nominations.
I'd like to. Is this thing? Is it on now?
Now.
Is it on now? I'd like to nominate Dr. Pamela Williston.
Okay. Any other nominations? Seeing none, I'll take a voice vote. Yays. And aye. Aye. Any nays or abstentions? Seeing none, welcome to the team, Dr. Lilson. With that comes the obligatory paddle. I think we should toss it around sometime, move the panel over. Okay. Yes. Do we have that? Oh, you did. Okay.
Yeah.
Okay, we are going to jump right in and have our student.
Well, she can't. She wasn't supposed to.
Oh,
That's
okay.
She-
That's
she
that's
has
what I
report-
that's what I was looking for as I was flipping. So we'd like to remind me your name, Eileen. Welcome, Eileen. And Eileen, along with another peer, is our student leader reporter, and we welcome you. And we look forward to you throughout the year, also inviting you to stay for as much of the meeting as you're able to. And again, understanding you have a full schedule, but do you have anything to share today?
So this is a relatively short one because it's been like a week since December's recap. But before winter break, the HV Choir program performed a successful magical dinner and are now planning for their January cabaret concert this Friday, the 9th, in the high school cafeteria. Our HV dance program also finished a wonderful winter dance festival performance. Casts for the musical Pippin have been finalized and shows will be in early March. Student Council culminated the year by wrapping with a successful Winter Spirit Week leading up to the pep rally. At the pep rally, our school's dance team performed for their second year, and both winter athletics and a choir performance were featured. The annual class dance-off was then held as each grade put in their best efforts and school spirit. Finally, during the break, girls basketball made a journey to Orlando, Florida, and had a successful performance at their holiday tournament. Looking forward, we will start the new year strong by having our National Honor Society induction ceremony this month to celebrate the academic successes of our upperclassmen. Thank you.
Thank you. And just, I'll hope as I go through things, I'll kind of point out the opportunities where we share or where things might be not written in the agenda. Just so we always offer an opportunity for the board to ask any questions or just acknowledge our student reporter. So anyone today, anything to ask or share? Okay, seeing none, I'll pass to Dr. Treese for any superintendent reports.
I will be keeping my comments brief as we have our the board's attorney Paul Green will be here to train the school board and their annual training. I just wanted to announce that our next meeting will be this upcoming Monday, January 12th. We will host it at the high school to accommodate all the guests that we have in attendance. It will begin at 6:30 in the community room at Central High School, and we'll be honoring our visionary principal of the year for the state of New Jersey, who is our own principal, Trish Riley, at the high school. We'll be honoring some of our transportation folks. The one, I don't know how many of you are aware that we had a bus that caught on fire in our backyard. And because of our bus drivers' quick action, they were able to move the other buses in the fleet away from that bus and was able to save other buses in that emergency situation. So we'll be inviting those individuals in to honor them, and also our retirees for the year will be at that in attendance. So we look forward to that very, very full agenda in addition to the other business that we'll be discussing on January 12th. With that being said, I'll pass it back to the board president.
Awesome. Well, I obviously don't have anything major prepared, but again, thank you for the opportunity to lead you again this year. And of course, I want to welcome back all of our staff and students after a long holiday. And I know with the weather, it's not an easy transition back. So we just thank everyone for their support in getting the schools back ready. Also, just wanted to acknowledge in terms of setting up the board for the new year, there will be conversations with Dr. Lilliston and myself with each of you around how we want to build out the committees this year. And some of you have already shared that information. So after this week, we can get to that work and set up our meetings. So as soon as we have everybody locked in, the committee leaders can reach out and set up the meeting, our first meetings in advance of our February meeting. That's all for now. Thank you. Any questions regarding kind of setting up committees outside of not minutia, but just anything of question or concern? Okay, seeing none, we'll move on to our favorite ethics training.
So
It is always good for everyone to be refreshed. As you know, this touches on a lot of areas in terms of how we meet, how committees, how we work in committee, etc. So thank you, Paul, for being here with us.
Thank you, Madam
I'm
President.
going to
Appreciate it.
usurp Paul for 1 second.
Sure.
Each of the board members at their nameplate tonight should have gotten a copy of the Code of Ethics and an acknowledgement of receipt of the Code of Ethics. If you guys could all sign that now. One of the obligations of the board secretary is to make sure that each member of the board gets a copy of that and the acknowledgement thereof back. Paul's going to be talking about this code as we go through, so just sign them and pass them down. John, did you get one? It's over there.
We'll get it to you. Thanks, Bob. We'll try to make this as painless as possible. So let's go to the first slide. So basically, we have the School Ethics Act, which is actually a couple of statutes in 18A, and it's there for basically reinforcing the importance of holding the respect and confidence of the public and avoiding conduct in violation of the public trust. Go to the next slide. Keep going. Okay, to whom does the School Ethics Act apply? It applies to two different classes. It applies to board members, managerial employees, and officers of the School Boards Association. There are two parts to the School Ethics Act. There's a statutory part that applies to all school officials, and then there's the Code of Ethics, which is what you have in front of you. That only applies to board members. Next. The regulation, why are we here tonight talking about this? Because the regulation says we must. Each district board of education shall discuss annually the School Ethics Act and the Code of Ethics pursuant to the statute at a regularly scheduled public meeting, which is what we are doing this evening. Next. The act itself, Section 1, talks about prohibited acts, which are conflicts of interest. Section 2 is the Code of Ethics. Go to the next slide. So the prohibitions, we're not going to go through them in detail, but they're essentially business conflicts, any kind of business that's doing business with the school district, any financial conflict, You may not use your position to secure unwarranted privileges or employment for yourself or members of your family, or act in your official capacity where you have a immediate family member who has a conflict of interest. Next section.
And part of this will be the board receiving very shortly a invitation from the School Ethics Commission to do a financial disclosure form.
Right. So that gets revealed in case there are any conflicts. You may not have any relationship with a business or organization that has an interest. If you do, that represents any person, party other than the board or district. The one area that there's an exception to that is you obviously can, of course, represent your own child if there's any kind of proceeding involving disciplinary proceedings, for example. But we would talk in that circumstance about making sure that you don't cross the line and basically do anything in violation of the Ethics Act itself. But you do have the right to represent your child. Next. Now the Ethics Code of provisions themselves. This is the board member provisions that you have in front of you. We're not going to go through every one, but we're going to go through some of the key ones. The first one is why you're here, which is that you make decisions in terms of the educational welfare of the children, seek to develop and maintain public schools that meet individual needs of all children, regardless of ability, race, creed, color, sex, or social standing. Next. Confine my board action to policymaking. Your role as the board, first of all, you individually have no authority except when you're sitting here together at a meeting as the board or in a committee meeting, basically, where you're charged with board business. So your role as a board member is policymaking. Basically, the way school boards often talks about it is the balcony picture. You've got the dancers on the ballroom floor. You're on the balcony overlooking the ballroom, setting the policy that governs the district. Making planning, policy making, planning, and appraisal, and you will only frame those policies and plans after you've consulted those who will be affected by them. Next. Board members formulate programs and methods to effectuate the goals through a variety of methods. Committees, you have ad hoc committees or standing committees. Sometimes you'll have a special committee to deal with a particular matter. Discussion and action at a duly convened meeting, which is typically where you would discuss and act on items. Next. Section D, you will carry out your responsibility not to administer the schools. Your job is not to run the schools. That's your administration's job. But together with your fellow board members to see that they are well run. We often get asked the question, well, how do I see that they're well run without administering them? Well, you have oversight. You have one employee that is directly responsible to you and who you are directly responsible for. That's your superintendent. There's a chain of command and everything flows through your superintendent. And that is how essentially you oversee the schools themselves. Next slide. When a violation is alleged of that particular provision, there has to be a showing that respondent is the term for a board member who was responding to a complaint before the School Ethics Commission, that the respondent gave a direct order to school personnel or became directly involved in activities or functions that are responsibility of school personnel. Next. So, for example, there was a case in 2005 where a board member asked for copies of SAT reports from the guidance secretary, took it upon himself to inspect lockers in the boys' locker room, and decided that he should instruct staff on supervision of students. Clearly, in that circumstance, that's a violation of the School Ethics Act. Again, you don't administer the schools, you oversee the administration of the schools. Next. Individual board members may not give direct orders to the administration. So, how do we deal with this particular circumstance? Board members may ask questions of administration relative to the process by which a recommendation is being made. You're certainly not a rubber stamp. You're entitled to information about why a recommendation is coming to you and why you're being asked to vote on something. You may engender conversations at the board meeting when the discussion occurs after a motion is made and seconded. Or you may ask the board president to return the recommended action to committee or make what under Robert's rules is called a motion to commit, which is not a reference to sending it to an insane asylum. Frankly, it's a reference to sending it back to a committee. Next. The board or a committee may direct the administration to perform certain tasks, functions, studies, analyses at any point. But again, that's basically a board determination. The board, a majority of the board can do that so long as they're consistent with the policy making, planning, and appraisal roles of the board. and or consistent with board goals or the superintendent's goals as well. Next. Appointment of personnel. This is very important. One of the areas that we often find issues with are confusion over the role in terms of appointment of personnel. The statute, it's 18827-4.1, makes it very clear that only the superintendent can recommend transfer, appointment, or removal of certificated or non-certificated employees. So you cannot take any action with respect to an employment situation without the superintendent's recommendation. And then it needs what we call a full majority vote of the membership of the board, which means that you have to have at least a majority of the full membership, which is, on a 9-member board, you'd have to have 5 votes, for example. It's distinguished from a simple majority where some actions you can take, where if you've got 7 people at the meeting, or maybe let's say 6 people at the meeting, you would just need 4 votes to adopt the simple, but here you would need a majority of the full number of the board members. So employment actions are a very specific area that are very carefully governed. And it's there basically to reinforce the superintendent's authority, and it frankly limits the board's discretion. The board can reject a recommendation, but it cannot be for arbitrary or capricious reasons, which means you have to have some solid grounds to reject the superintendent's recommendation. Since we're not the experts in the area, the superintendent is the educational expert and makes the recommendation. Next. Authority rests with the Board of Education. You may not make any personal promises nor take any private action. For a violation, you may have evidence that the respondent made personal promises to somebody to accomplish something, or took action beyond the scope of your duties that by its nature had the potential to compromise the board. And later on, we'll see, we always have a quiz that there's a case that recently came down that had a little split between the administrative law judge and the school ethics commission on whether a particular action had the potential to compromise the board and what that means. Next. I will refuse to surrender my independent judgment. Very critical. You are elected to act as an independent Board of Education member in the sense that it is your judgment as a board member that the voters put you in here for, and you may not surrender that judgment to special interest groups or partisan political groups, nor may you use the schools for personal gain or the gain of friends. Next. Hold confidential all matters. This is probably one of the biggest areas where we find violations. It's sometimes difficult to do, but like they say, whatever happens in Vegas stays in Vegas. Whatever happens in closed session stays in closed session. Anything that is discussed in closed session has the potential typically to needlessly injure individuals or the schools, and you must hold it confidential. And then the other part of this is that in all other matters, I will provide accurate information, where oftentimes people run afoul is they will put information out that proves to be inaccurate. The early cases typically came down with the budget situation where board members were making claims about budgets that were not correct, and they basically were held accountable for that. Next. Support and protect school personnel and proper performance of their duties. Your goal and your object here is to be supportive of your administration and your staff. If there's evidence that you took deliberate action in undermining, opposing, compromising, or harming school personnel in the proper performance of their duties, that would constitute a code violation. Next. Complaints. All complaints go to the chief administrative officer, that's your superintendent. You will act on complaints at public meetings, so you don't act on complaints privately, and only after failure of an administrative solution. It's very rare that you should ever have to get to that point. Typically, they will be resolved by the chief school administrator, and oftentimes if they're not, frankly, at that point it winds up in litigation, and it's not something typically that a board can really resolve. Next. There's a question of the code doesn't explain how you refer complaints. 2 options. You may make the complaint or refer directly by yourself, or you may direct the constituent to go directly to the chief school administrator. Oftentimes what we suggest is that if it's a specific issue with regard to, for example, a staff member, that the public members should be advised to follow the chain of command. First discuss the issue with, if it's a teacher concerned, discuss it with the teacher, then the principal, and ultimately then the superintendent. Next. Who can file a complaint? A complaint with the School Ethics Commission can be filed by anyone, except it's any person. So a Board of Education cannot file a complaint. There's a 6-month statute of limitations for filing. Next slide. We have the School Ethics Commission. That is the entity that basically oversees the School Ethics Act. It's the only entity that can determine whether an official's conduct violated the act. And you can request an advisory opinion from the SEC about your own or someone else's proposed course of conduct. Those are advisory. They're not binding, but they give you an idea of how the SEC views a particular matter and how they would rule on something. And they offer you protection because if you follow an advisory opinion, the SEC, frankly, will be hard put to later on determine that you violated the act. Next. Any school official may request an advisory opinion. If it relates to the conduct of another official, that official must be copied and may file a response. Next slide. There are sanctions for violations of the act. They go from reprimand, which is basically slap on the wrist, if you will, censure, which is a more formal and more serious public condemnation of the action, which includes reading the resolution at a board meeting and posting it around town. Suspension, they can suspend a board member for a period of time, and in very severe cases, they can actually remove a board member from office. That does not stop the board member from running again, but they are removed from their current term. Next. Bob mentioned this, that you are going to have financial disclosure forms that you have to fill out. They have to be filed within 30 days of being sworn in. And if you're a returning school official on or before April 30th, this is just there to kind of remind you of this fact. And that basically, you have to reveal essentially any potential business that you have. We're looking for any conflicts of interest. It's basically a financial disclosure statement. They also have to be approved by the executive county superintendent. Next slide. This obviously is not readable. It's there just to remind you that there are a lot of areas of conflict of interest in negotiations. Fortunately, I don't think we have anything immediate. You don't have to worry about it soon, but if you are on a negotiations committee, you have to be aware that if you have any family members, and we're not going to get into tonight what a family member is, but it's typically your close relatives, who are either employed in the district or who are a member of a state association such as the NGEA in another district, you're going to have potential conflicts in terms of your ability to participate in collective negotiations or discussions of those negotiations. Just be aware of that. We don't have to get into it tonight. Next. Free speech issues. You do have First Amendment right to express yourselves, but again, by the Ethics Code, you may not disclose information which is inaccurate, which is confidential, or which has the potential to compromise the board. Next slide. And you should, I basically said that you should not publicly criticize the staff members themselves. Now, you can certainly, criticize a proposed course of action, a proposed policy, it's something that you disagree with, but not the staff members themselves. Next. You shall not represent your personal opinion as the position of the board. Include in all formal expressions a disclaimer. So if you write a letter to the editor, which I would encourage you, frankly, not to do, that you basically have to identify yourself as a member of the board and state that you are speaking as a private citizen and that the opinion you are expressing does not necessarily represent those of the board. On top of this, the SEC has also said that there are often circumstances, and we'll see a couple later, where a disclaimer is going to be ineffective anyway, because you may say all you want, you're acting as a private citizen, when it's very clear from the context that you're clearly speaking as a board member. So you have to be very careful when you comment publicly on any board matters. Next. Here's a sample disclaimer, which basically says I'm speaking as a private citizen, that these are not representative of the board and totally represent my own personal opinion. Next slide. This is the Treston case, just which we mentioned because that was a case where a board member wrote an op-ed endorsing candidates. He did include a disclaimer that he was writing it on his own behalf, and the opinions were his own, but he did not include the part that says these are not endorsed by the board in any sense and not the board's position. And he used terms like we and our, and basically it was confusing because the SEC found that it created the appearance that the entire board was endorsing certain candidates, and that ran afoul of the act. The ALJ, administrative law judge, we have these cases go typically before the Office of Administrative Law, where administrative law judges do an initial hearing. They're the fact finder. They make a report, a recommended initial decision, which the SEC then reviews. ALJ recommended a reprimand. The SEC said this is severe enough that it should be a censure. Commissioner reduced it to a reprimand since he said, well, you tried at least, even though you didn't quite do it sufficiently. But again, the case law since this case has increasingly said that there are circumstances where disclaimers, no matter how carefully you write them, are not going to be effective. Next. Just one thing I would urge you to do is look at your bylaw 169, which is your bylaw that deals with internet emails, OPRA, which is the Open Public Records Act, and OPMA, which is the Open Public Meetings Act, which govern the conduct of the board in terms of maintenance and access to public records and what it has to do in terms of noticing and conducting meetings. Very important that you be familiar with this particular regulation bylaw. Basically, it talks about the potential for inappropriate or improper disclosure, breach of confidentiality. What I always say is don't put anything in an email that you don't want to see on the front page of the newspaper, essentially. There should be nothing confidential in an email. You should not have email going back and forth between board members discussing a particular topic, because that could be held to be essentially a serial meeting in violation of the Open Public Meetings Act. So be aware of those concerns and take a look at this bylaw, because it's very important. Next. Okay, some questions, some quizzes. Is it a violation? First one, returning board members have seen this one before. We like to put it up because it's useful to kind of go over what's the extent of your outside volunteer activities, and do they conflict with board membership? Is it a violation of the act for a board member to serve as an executive officer of the PTA or any other executive officer position? This advisory opinion says it is not. Next slide. Basically, under volunteering, you may participate in outside organizations that are self-governing and independent of the board. PTA, although it has a very close relationship with the district, is an independent organization. You must recuse on voting and be careful not to enmesh your role as a board member when there's the activity of an organization involved. You may not supervise school personnel or funds. You may not have regular contact with students or staff. You may not have an active presence in school functions. You cannot serve as a volunteer coach, club advisor, etc. If there's extensive involvement with school personnel and with extensive fundraising, that presents a concern. Next slide. So, having said that, how about this one? Go back. Okay, go forward. There we go. We're going around. Okay. Got a board member. Before she became a board member, she co-founded the CPAG, the Special Education Parents Advisory Group. She continued to hold the leadership role after the election and was also chair of the board's Special Education Committee. Did she violate the School Ethics Act when she sent an email from her board email account to the CPAG members advising that she intended to attend an upcoming board meeting as CPAC co-leader and not as a board member? And the answer is she did. That was a violation. Next slide. So what the School Ethics Commission said is there's no inherent per se conflict of interest in serving as the board member and CPAC leader. They found this is akin to membership in the PTA, as we've seen before, or there was an earlier advisory opinion that held that being in a special education parent discussion group was not a conflict of interest in and of itself. That you would not reasonably be expected to prejudice your independence of judgment in the exercise of your official duties. But here, board member crossed the line. She blurred the line between her role as a board member and the CPAC leader because she was now advocating on behalf of special education students and their families. You can say certainly what's wrong with advocating on behalf of special education students and their families, and certainly that's a bona fide position to take, but you have to be very careful because the board has its role and the parents have their role, and you can't really blur the line between the two. You have to be very careful, essentially jealous of guarding your role as a board member and not cross over to that line of advocating on behalf of families. Now, there could be times when you could take a position as a board member in support of various special education initiatives, for example, and that's not going to cross that line. But here she clearly went essentially and said, I'm going to be here as the representative of the parents and not as a board member. You can't do that. Next. Here's another one. Board member prior to the election had been an active community member, occasionally, if not often, at odds with prior board administration. Posted board-related comments and information on her Township Watchdog Facebook page, many of which did not have a disclaimer. Next. That is true. It was a violation. So her post had a clear nexus. They look for a connection between the post and your role as a board member. Her posts were clearly relevant to the board business. Even the posts with disclaimers. Again, here's the circumstance where essentially the SEC is saying, it doesn't matter that you had a disclaimer. You're writing about board matters and matters that you had knowledge of because of your position on the board. And clearly, the public is going to see that as acting as a board member or speaking as a board member, no matter how much you disclaim it that you're acting as a private citizen. The ALJ found the respondent used her position to secure advantages. She was trying to support board candidates that she supported in the election. She made personal references to board matters that could have compromised the board, and she supported a political group, which was the surrender of her independent judgment. Given the context of the post, the commission agreed that a reasonable member of the public could perceive she was speaking in her official capacity or pursuant to her official duty. So the context is very important in these kinds of cases. Frankly, I would urge you not to have any social media comment whatsoever connected to the board activity. Next. Now, here's another one. Board member violated School Ethics Act when he used his personal social media account to respond to social media posts concerning potential banning of books in school. That post generated responses from the public who asked for clarification and the members' thoughts on banning books. Again, no disclaimer was included here. And that was a violation. And it's interesting, though, because the administrative law judge found that the posts were interpreted reasonably as being made in the capacity as a board member. So really, the disclaimer was not really an issue because clearly this board member was speaking as a board member, which, by the way, your policy says that the board only has one spokesperson, or technically two. One spokesperson for the board is the board president. Your superintendent is the spokesperson for district matters, not directly pertaining to the board itself. But the ALJ found here there's no factual evidence that the posts had the potential to compromise the board, because keep in mind there's two prongs to this. You make that as a capacity in your capacity as a board member, and it had the potential to compromise the board. School Ethics Commission disagreed with that. They said, yes, clearly there's a nexus here. Clearly they're connected. But the comments did have the potential to compromise the board. As first place, staff were expressing concerns as a result of this. They were wondering what's going to happen with what's in our libraries and what materials we're teaching. And keep in mind there's no discussions occurred at the board level yet. This is purely public, commentary that's going on. And second, the poster was talking about potential board actions because this could come before the board. So I would encourage you to do what courts do, which is basically not to comment at all on any matter that may come before them, essentially. If there's going to be a comment or a statement put out, it should come through the board president officially on behalf of the board. Next. Board member violated Section D of the Act. This is an easy one. As we said before, you can't be a coach or an assistant coach even if you're a volunteer. So that's a violation of the Act. Next. Board member owned a spiritware company. Did he violate the Act when he sent emails to the school principal asking to send emails to students and families to promote the sale of spiritware for parent and staff association? This is a parent-staff association, like a PTA fundraiser, and everything is donated. He's not making a profit from the sales, but it is a violation of the Act. You still can't do it. Next. Again, because it was a personal interest, that was found to be a conflict of interest. Board member founded a nonprofit entity. What I've asked here is, did she not violate the School Ethics Act when at the school workshop, the annual school board's convention? She goes around wearing an identity badge with her board credentials, and the board, of course, paid for her to be at the convention. And she's also wearing a shirt promoting a nonprofit that she's created, nonprofit entity. She live streamed her interactions with vendors, introduced herself to 3 vendors, in particular stating in part that she was the board vice president She owned her own profit. Oh, by the way, I have this great nonprofit. It's so and so, and here's our program and what we do. That was a violation of the act. She did violate the act. Next. She basically attempted to use her official position to secure business relationships with a nonprofit. Doesn't matter that it's a nonprofit. She's still seeking business relationships with a particular entity that she's created. And a reasonable person would view that she was lacking objectivity while performing her role as a board member and promoting her nonprofit. So they found a couple of violations there. Next. Board member received vendor information at the convention. Made that board member contact each vendor to ask about pricing and contact other school districts that use the equipment. No, that board member may not do that. Basically, next one. Board member violated the act. She took official action to effectuate policies and plans without consulting those affected. She has no right to contact the vendors in other districts unless the board directs her to do so, frankly. She identified herself as a member of the board, indicated the board was contemplating switching from MacBooks to Chromebooks, although the board had not even considered any change. This was considered pretty severe. They censured her for this one. You have to be very careful that you don't take any official action and start taking it upon yourself to go talking to other vendors without basically being charged by the board to do so. Next. Member violated the SDA, where after the superintendent denied the member's request to have code of conduct violation removed, communicated directly with the superintendent several times, emailed other board members without indicating she was doing so as a parent, although frankly she shouldn't have done so as a parent either, and the board attorney, and the spouse raised an issue in public comment at a meeting. It was a violation of the act. Next slide. Next. There we go. She made repeated communications, trying to persuade board members, board council, superintendent, reverse course. Again, you have a right to represent your child in disciplinary proceedings, but here she went beyond the pale. And one thing you always have to be careful of is, even though you're coming in as a parent to meet with the teacher, for example, you're still seen as a board member. There's still a lot of clout behind that, and you have to be very, very mindful of that and very careful to stress that, hey, I'm here as a parent. This is all about my child, and that's all I want to talk about, essentially. I mean, here she actually tried to provide a direct order to school personnel. Board member would violate code of ethics by participating in initial and or exit interviews. That would be a violation. This advisory opinion held, frankly, I don't know that it's correct, or that I agree with it, but they held that by participating in initial interviews or exit interviews, you are actually administering the schools at that point, and violating that provision of the School Ethics Act. They have reluctantly said that in certain circumstances, you could have one or two board members kind of observe interviews, especially for higher level administrators, but they can't participate. They can only be there to kind of see the process. And that was kind of a begrudging acknowledgement by the SEC. Next. Okay, violation of Section G of the code by inadvertently replying all to an email that include the board and a parent who brought the complaint to the board. So it was an accident, it was inadvertent, and it was a violation because it doesn't matter. Intention's not important. The key is that by replying all, the board member revealed confidential information, even though it was not intentional. So one of the things I usually advise is do not reply to all. DNRTA. Next. Just a bonus question. A board member can review a staff member's file, A, only with approval of a majority of the board, B, without board input, C, upon notice to the board administration, or D, if there is action pending before the board with respect to that employee. The answer is D. The only time that a board member can review a staff member's file is when the board is being asked to take a specific action with respect to that employee. And in that circumstance, the board members are entitled to have the background information. At no other time do you have the right or the ability to see personnel files. And that's it. Any questions? I thoroughly numbed everybody, probably. Thank you.
I have a question. I think one of the common questions that comes up among board members is around communication with the public through email. So if a parent or a community member sends an email, what can individual board members do in response to that email who are not the board president?
They can forward it to the board president and superintendent and basically respond. You might even want to have an automatic response. Some boards do that, which say that thank you for their email. Pursuant to the School Ethics Act, I'm not permitted to respond directly, but I'm forwarding it on to the superintendent for comment. They should not respond directly, other than to say I've sent it on to the superintendent for review.
I have another question. This is more a curiosity of mine because I recall it coming up, I think, 3 years ago when I did my first year training. Are board members required, if they are also parents who have children in the school district, to declare themselves as board members in their communication with staff or like teachers as it relates to their child?
You're not technically required. If you're basically doing that, it's not a bad idea. Just to say, make you aware that, I am a board member, but I'm speaking as a member. You don't have to. It's not mandatory that you do that. It's just very, it's best to, frankly, especially when you meet with people, that you not raise that. That you not say to them, I'm a board member. Basically, I'm saying when you meet directly with them, it's probably better not to actually tell them that, because then they could argue you're intimidating them.
That's interesting because during my training,
right.
This is the reason it's come up for me.
Right.
Is I recall
It's
them
very
actually
confusing.
saying,
You should identify
if
yourself.
you are emailing your
I would say if you're emailing,
child's teacher,
I would put
say,
it in.
I'm a board member. I'm writing this in my
Yes, I'm
capacity
saying
as a
I
parent."
would put that in the email. I would put that in the email. But when you meet directly with them, especially, if you're talking about that, I find it personally better not to kind of raise that in the conversation directly one-on-one, because that could get taken out of context or twisted around on you. If it's in writing, it's clear. If you're meeting one-on-one, they could argue that you're essentially trying to intimidate them. That's my concern with that. But definitely I would put it in an email.
And also, I think another question, I know it came up for me in my first year or two. You talked about not replying all, but also you can't CC a quorum of the board on an email also. Do I remember that correctly, or it becomes a meeting?
That's correct. I mean, it has the potential to, yeah. You want to avoid that, because you want to avoid having more than the quorum involved in a discussion. The danger is that people start responding. Arguably, if you just CC everyone, it's not a problem, but the recommendation is just err on the side of caution. Other questions? Those are good questions. Okay. Thank you.
Any other questions? All right. Well, he's on speed dial. I'm just checking. That's right. Okay. Favorite part. Members of the public are invited to address the board on any matter for a maximum of 3 minutes during this portion of the meeting. You are asked to state your name, address, and municipality. In response to your comments, the Board of Ed may respond or direct the superintendent to do so. The board may also opt to take up the matter in a future meeting so that the matter is researched by the district administration. Public comment is now open, and I'll remind you that there is a booklet at the dais to sign in, and there are some timekeeping notes.
Yes. So I am the timekeeper. I'll be keeping time. You have 3 minutes for public comment. At 2 minutes and 30 seconds, I'll hold up the yellow sign, and then when the 3 minutes is over, I'll turn it to red.
Thank you. Public comment is now open. Okay, seeing none, public comment is now closed. I need a first and second to move the consent agenda items.
Motion.
Second.
All in favor? Any opposed or abstaining? Seeing none, consent agenda passes. Okay, are you going to cover personnel? Okay. Can I get a first and second for personnel? Okay,
There were just a few items that were put on tonight's agenda as they are time sensitive. Next week we will have our regular personnel agenda.
roll call vote.
Dr. Genovese. Dr. Lilliston. Mr. Peters.
Yes.
Mr. Slotman.
Yes.
Dr. Ciliano.
Yes.
Ms. Cotter. And Ms. Williams-Galliano.
Yes,
Motion carries.
wonderful. Any new business items? Okay, seeing none, we will have another public comment. I need a first and second to approve the calendars for January and February.
Motion.
A second.
And again, we're not going to set committee meetings tonight. We'll wait till the president and vice president set the committees. But we do want to approve it because we're moving, as Dr. Tree said, we're moving the meeting next week to the community room at the high school to accommodate the many presentations that we have.
All those in favor? Any opposed or abstaining? Seeing none, meeting is moved. Okay, now public comment. Members of the public are invited to address the board on any matter for a maximum of 3 minutes during this portion of the meeting. You are asked to state your name, address, and municipality. In response to your comments, the Board of Ed may respond or direct the superintendent to do so. The board may also opt to take the matter up at a future meeting so that the matter is researched by the district administration. Second public comment is now open. Seeing none, public comment is now closed. And now I need a first and a second to move us into executive session where personnel matter of employee 4018 will be discussed. No action will be taken. All in favor? Any opposed or abstaining? Seeing none, we are now moving into executive session. Thank you all for attending our first 2026 meeting.